Swayam Prabha. Digital India. Educated India.
Hello everyone, I am Dr. Kavita Solanki, Professor of Law at University School of Law and Legal Studies, Guru Govind Singh Indraprastha University, Delhi, Dwarka. Today we will talk about Labour and Industrial Law 1, into which we will talk about Industrial Dispute Act 1947, and this is lecture number 4. This act contains total 7 chapters, 40 sections and 5 schedules. This act came into force on 1st day of April 1948. It extends to whole of India. This act has been amended so many times. This act is, the purpose of this act is to maintain a cordial relation between the employer and the employee. This act is the provision for the investigation and the settlement of the industrial dispute and to contain other purposes. Just to make the investigation, we are having, and to settlement the industrial dispute under this act, we are having non-adjudicating authorities as well as adjudicating authorities. And to encourage the collective bargaining, to maintain industrial peace by preventing illegal strikes, to prevent illegal lockouts, and to provide the layoff and the retrenchment compensation to the employees. This act protects the workmen against unjust treatment. When we talk about this act has been amended so many times. This act has been amended when it was amended in 2008. There, into that, a grievance redressal committee has been set up, and it has been mentioned into this amendment, where into any of the establishment with more than 20 workmen, they can establish the grievance redressal committee who would be hearing the individual's grievances. When we talk about main feature of this act is, it is applicable to the industries with and certain categories of the industrial workers. And it is interesting to observe that whereas other labour laws are restricted in their application to the factories or the establishment employing a certain number of the minimum employees, this act does not impose any restriction, because when we talk about the other act, the number of the employees or the threshold has been there. This act would be, there is no threshold, no limit has been given. So, this act can be applied without the threshold of the employees. It lays down the comprehensive machinery for the prevention and settlement of the industrial disputes, and the objective of this act is to settle the disputes, and we are having the different methods, different modes of the settlement has been given. So, we are having the non-adjudicating process, into which we are having the work committees, we are having the conciliation officer, we are having the board of inquiry, and we are having the board of conciliation. So, we are having this thing, that is without going to the court, the matter can be resolved. And when we talk about adjudicating authorities, into which we are having that is in section 7, we are having the labour courts, we are having the tribunals, that is in section 7A, and we are having the national tribunals, which has been given in section 7B. So, they would be deciding the matter, because into this act schedules has been provided and the jurisdiction has been given it to these authorities. So, they can take up the matter which has been given into those schedules. So, respectively the schedules are there and they can decide the matter. And after making the amendment in 2010, now the grievance redressal committee has been set up. If into any of the industry they are having the number is 20. So, just to settle the dispute, we are having the grievance redressal committee is there. And into this act, we are having the voluntary arbitration. So, that is one of the method. So, voluntary arbitration is there. So, these kind of the disputes can be resolved with the help of the third party. So, the purpose is just to just to minimize or remove the conflicts between the parties. Into this act, certain practices on the part of the employers and the workmen have been declared to be the unfair practices. For this, we are having the schedule 5, into which the practices has been given, and the category has been given what kind of the practices are amounting to the unfair practice on the part of the employer and on the part of the workers. So, if someone is going for the unfair labor practices, penalty has been, we are having the penal provisions given under this act. So, into this act we are having important definitions has been given. So, when we talk about the definition of the appropriate government, that is given in section 2A. In relation to any industrial dispute, central government can be the appropriate government, and for some other cases the state government can be the appropriate government. So, accordingly this dispute can be decided by the respective appropriate government. We are having the definition has been given the average pay. This is a very important definition, because when we talk about layoff compensation or the retrenchment compensation, normally we take the help of the average pay is very important. So, into this definition it has been mentioned that how a average pay can be decided. In section 2B, award has been defined. So, an interim or the final determination of any of the industrial dispute or of any question relating to thereto by the labor court or the industrial tribunal or the national tribunals, they include the arbitration award which has been made here under section 10A. So, when we are talking about that is a award is there, because if any kind of the order has been given by this authority, that is a final, they must have to make the compliance of it. So, that has been, and into this act arbitration award is considered under this industrial dispute act. We are having the board. Board means we are talking about the board of conciliation which has been constituted. A few important definitions. Definition of closure is given in section 2 clause C. It means permanent closing down of a place of the employment or part thereof. We are having the conciliation officer, means a conciliation officer who has been appointed. Conciliation proceedings means the proceedings which has been held by the conciliation officer or the board of conciliation. We are having the court. The court has been given, it means the court of inquiry is there. And when we talk about the definition of the employer here under this act, means in relation to an industry carried on by or under the authority of any department of the central government or the state government, the authority prescribed in this behalf, and where no authority is prescribed, the head of the department, because when we talk about either the central government is the appropriate government or the state government is the appropriate government. So, employer would be whom these government they would be appointing, the person would be the employer, but if no one has been appointed, then the head of the respective department would be the employer. And in relation to any industry carried on or by on behalf of the local authority, the chief executive officer of that authority. So, when we talk about at the local level, so at the local level, so chief executive officer would be considered to be the employer. In section 2J, definition of the industry has been given. It means any business, trade, undertaking, manufacture or calling of the employers, and includes any calling, service, employment, handicraft or industrial occupation or avocation of the workmen. So, when we talk about definition of the industry, this definition is, that is when we talk about this definition, so we are dividing this definition into two parts. So, first part is that is deals with any business, trade, undertaking, manufacture or calling of employers as the main hub of the definition. So, it includes 5 things basically. These 5 things are business, undertaking, manufacture, trade, calling of the employers. So, that has been explained in a wider form, and it includes, that is, it covers mainly from the that is from the point of view of the employer. So, it is a part 1 is basically it is showing the employer point of view. When we are talking about the part 2, that is calling, service, employment, handicraft or industrial occupation or avocation of the workmen, that is from the point of view of the employee. So, this has been explained in that way. When we are talking about what do you mean by the industry is, so this definition has been given in section 2J of the Industrial Dispute Act 1947. Later on, this definition has been amended in 1982. But when we talk about one of the important case, that is a initial first case which came before the court, was whether the municipality would be industry or not. For this, we are having the case D.N. Banerjee versus P.R. Mukherjee, and into which, so the case came before the court whether the municipality is an industry or not. So, the case was D.N. Banerjee versus P.R. Mukherjee in 1953, where the name of this case is Baj Municipality, some says Baj Municipality case. So, into this case, what happened, one of the clerk and the inspector, they had been removed. They were doing the work here into this municipality, and so when these persons, they were removed, they filed a suit. They went to the High Court and they said the municipality is an industry. So, they were asking for the other kind of the benefits, but the court rejected it, and so they went to the Supreme Court. When the appeal, they went to the Supreme Court. The court held that municipality would be the industry, because the reason is, the court held that the municipality is having the so many departments, like the fire brigade department and the public work department, because if the someone is not getting any kind of the profit, and where the profit motive is not there, that doesn't mean it will not be coming under the definition of the industry. So, it has been held that is the municipality would be coming under the definition of the industry. And in another case, Borog municipality, again it has been held that it would be coming under the definition of the industry, because municipalities does not mean they would be making the money. So, they have reaffirmed they have taken this Baj municipality case, and accordingly it has been held that municipality would be coming under the definition of the industry. And it has been clearly mentioned that the profit motive is not essential, and only that is not the criteria whether they are making the money or not, because industry means if any undertaking is running without the profit, even though it can be the industry. Sometime when we talk about the charitable institutes, so all the time the profit making is not the intention of the industry or that particular department. So, we are having so many cases. In the year 1978, in the case of the Bangalore Water Supply Sewerage Board versus A. Rajappa in 1978, the matter came before the Supreme Court, and the Supreme Court introduced the triple test. And into this case, it is very important to meet out these three components with the three triple test, means they have to satisfy these three conditions if they want to, if any of the industry or the establishments want to come under the definition of the industry. So, that is only the profit motive is not the intention. And the same definition has been taken after when the amendment was made in 1982, and has been defined the definition of the industry. So, industry means any systematic activity carried on by the cooperation between an employer and his workmen, whether such workmen are employed by the employer directly or by or through any agency. or by the contractor. So, direct, if the someone has been employed, the person would be coming under the definition of the workman, or if the person has been indirectly through any agency or through contractor, he would be coming under the definition of the workman. And the third point is for the production, supply or the distribution of the goods or services with a view to satisfy the human wants or the wishes. So, it would be coming under the definition of the industry. When we talk about triple test, it means that is any kind of the industry, there should be the systematic activity, there should be the cooperation between the employer and his workmen, and for the purpose of the production, supply or distribution of the goods or services with a view to satisfy the human wants or the wishes. But here wants or the wishes which are merely of a spiritual or of a religious nature, they have not been included under the definition of the industry. So, this definition they have taken this triple test from the definition which has been given in section 2J of the Industrial Dispute Act. So, now this definition has been taken, has been amended in 1982 and into the Industrial Dispute Act and defined in section 2C of the Industrial Dispute Act. And the criteria and has been held that along with the triple test, whether that industry is, whether or not any capital has been invested for the purpose of carrying on any activity. It is not necessary for the industry the capital has to be invested by the employer, no. So, any capital has been invested for the purpose of carrying on such an activity, or such activity is carried on with a motive to make any gain or the profit. So, it can be, or it is not necessary the intention is to gain the profit or gain from that industry, and it includes any activity of the Dock Labour Board established under section 5A of the Dock Workers Regulation of Employment Act 1948, any activity relating to the promotion of the sales or business or both carried on by any establishment would be including under the definition of the industry, but does not include any agricultural operations, hospitals or dispensaries, educational, scientific research or training institutions, they are not the part of the industry. Institutions owned or managed by the organizations wholly or substantially engaged in any charitable, social or philanthropic services, or khadi or village industry, or any activity of the government relatable to the sovereign functions of the government, including all the activities carried on by the department of the central government dealing with the defense research, atomic energy and space, or any domestic service, or any activity being a profession practiced by an individual or body of the individuals if the number of the persons employed by the individual or body of the individuals in relation to such a profession is less than 10. Any activity being an activity carried on by the cooperative society or a club or any other like body of the individuals if the number of the persons employed by the cooperative society, club or like other body of the individuals in relation to such a activity is less than 10, they will not be coming under the definition of the industry. Because we are having so many cases where either we are talking about that is a Gymkhana club, or we are talking about Safdarjung hospital, whether we are talking about, we are having so many cases where the exceptions, due to these exceptions, these institutes or the organizations, they have not been included into the definition of the industry. But when we are talking about the codes, under the code, the exceptions has been, because we have taken the as it is definition which has been given in after making the amendment in 1982, the as it is definition has been taken, but only with the limited exceptions. So, under the code, along with the triple test, it has been mentioned that if the someone is doing when we are talking agriculture operations or hospitals or now the hospitals and the dispensaries, they are coming under the definition of the industry. Educational, scientific, research or the training institutions under the code, they are under the definition of the industry. And when we are talking about any activity being a profession practiced by a individual or body of the individuals, if the number of the persons employed by individual or body of the individual in relation to such a profession is less than 10, would be coming under the definition of the industry. Say sometime when we are talking about law profession, when we are talking about the medical profession or chartered accounts or any NGO. So, if we are having this kind of the group of persons, they are even less than 10, they would be coming under the definition of the industry. So, now under the code, any domestic services, they are not they come under the exception, they are not coming under the definition of the industry, or any activity of the government relatable to the sovereign functions of the government. So, they are not the part of the industry. Or when we talk about any agricultural operations, they are not the part of the industry. And when we talk about, one more exception is there, institutions owned or managed by the organizations wholly or substantially engaged in any charitable, social or philanthropic services, they are not the part of the industry. So, with the limited exceptions under the code on the industrial relations, so rest would be coming under the definition of the industry. The next is again a very important section, that is section 2 triple K. It means the layoff has been defined here. It means failure, refusal or inability of an employer on account of shortage of coal, power or raw materials, or the accumulation of the stocks, or breakdown of a machinery, or natural calamity, or for any other connected reason, to give the employment to a workman whose name is borne on the muster rolls of his industrial establishment and who has not been retrenched. So, layoff means the first condition is every workman whose name is borne on the muster roll of the industrial establishment and who presents himself for the work at the establishment at the time appointed for the purpose during the normal working hours or any day. And if this workman is present, but the employer is not able to assign the work to him because of these reasons, say if the employer feels fail or refusal to give any kind of the work, or enable due to shortage of the coal, because if the work is because they need the coal for that work and the coal is not there to that extent, and due to the shortage of the power is not there and shortage of the raw materials, so they cannot do the work, or the accumulation of the stock which was required, that is not available to that extent, or the breakdown of the machinery, because now this machinery has been, due to the breakage of this machinery, it is not possible to carry out the work, or due to the natural calamity. Or for any other connected reason, to give the employment to the workmen. So, if the employer is not able to assign any kind of the work to this workman whose name is given, mentioned into this their muster roll of the industrial establishment, so he would be entitled to get the layoff compensation. And for this purpose, if the workman is coming during the normal working hours and on any day, and is not given any employment by the employer within 2 hours of his so presenting himself, shall deem to have been laid off for that day within the meaning of this clause. So, if the person makes him available, if the workman makes him available and he was waiting into the industry, but he has not given, he was available, he present himself, but within 2 hours no work has been assigned to this person. So, for the purpose of this section, the person would be considered to be the laid off. So, when we talk about the laid off, sometime if the person has been retrenched, any workman has been retrenched into any of the industrial establishment, he won't be coming under the definition of the layoff. So, retrenched worker would be, the protection would be given to the retrenched worker under the retrenchment, not under the layoff. He will not be considered to be the layoffer. And if the workman, instead of being given the employment at the commencement of any shift for any day and is asked to present himself for the purpose during the second second half of the shift for the day and is given the employment, then he is deemed to have been laid off only for the half of the day. Say if the workman present himself because he had been called, so he was available, but he had to wait for the first shift and no work has been assigned to him, and he has been given the work for the second shift. It means the person would be considered to be the layoff for the first shift. And when we talk about provided further, if he is not given any such employment even after so presenting himself, he shall not deem to have been laid off for the second half of the shift for the day, and he shall be entitled for the full basic wages and the dearness allowances for the part of the day. Say if only the half of the shift work has been given to the workman, so he would be entitled to get the other allowances for the for the period for which he was present, and the dearness allowances has to be given for the period for which he had been laid off. So next is section 200, that is retrenchment. It means termination by the employer of the service of a workman who for any reason whatsoever otherwise than as a punishment inflicted by way of the disciplinary action. So when we are talking about the retrenchment, first is the retrenchment is not the punishment which has been given by the employer, and it is not any kind of the disciplinary action has been taken by the employer against the workman. Only when we talk about retrenchment means that is the termination by the employer of the service of the workman and for the reason. So the reason is, when we talk about retrenchment is for the retrenchment, section 25F, it talks about the condition precedents to the retrenchment of workmen, and these conditions they must have to be fulfilled for a before going for the valid retrenchment. So this section 25F, it applies only to the workman who has completed 1 year continuous service. So it is very, very important that if someone wants to get the benefit of the retrenchment compensation, the person must have to complete the 1 year continuous service. This is the first condition. And when we talk about that is the procedure for the retrenchment is, it is a duty of the employer, if we want to give the retrenchment of any of the workmen, he has to serve the notice to the workmen, and into that notice he must have to cite the reason, and it is the duty of this person is, duty of the employer is a 1 month advance notice to be given to the workmen before the retrenchment. Sometime what happened, if the employer is want to make the retrenchment immediately, then in that case, because normally when we talk about that is use of this is the notice period, why we give the notice is, that is number one, the person would be preparing himself, and so and if the notice has not been prepared, not given, then in that case this is a duty of the employer is he has to give the 1 month salary for this notice period, and it is mandatory that, because if the employer cannot take any kind of the excuse, if the employer is not paying the wages for this period, if the employer has not given the notice, then he would be giving that wages for that month. And if the retrenchment is, if the person had completed the 1 year, this workman has completed the 1 year, now the question comes what to pay to the workman. So then in that case 15 days average pay would be given, and they must have to count it on the basis of the number of the number of years he has completed into that establishment. And when we talk about this thing, the employer only provided, so this if the person has completed 1 year of service, so the retrenchment, this kind of the compensation can be given only when the person exceeds the 6 months of this service, and employer has to give the notice to the, now for the retrenchment is, if he is planning something into the prescribed manner to the appropriate government, because it is the duty of the employer to inform the appropriate government, and if employer is not complying with these conditions, not informing the government, so this retrenchment would be considered to be the void, so that would be it will not be effective. And and this section 25F is not applicable to the closed or the dead industry. So section 25 will not be applicable, these conditions will not be applicable for the retrenchment if it is a case of the dead industry. When we talk about procedure for the retrenchment is section 25G recognizes, the procedure has been given, and that is the principle, based upon the principle is, that is last come first go. So it means who joined last come first go, who joined last would be going first. So this is the principle. But when we talk about this section, it is not apply absolutely, because for this section will not be does not apply on two conditions, where if the person is not a citizen of India, or agreement made between the parties, between the employer and the workman, providing for a different procedure for the retrenchment. Already they have entered into such a kind of the agreement, they would be following the different procedure for the retrenchment, they can go by that. But it is the duty of the management, that is they must be satisfied that if they would be following this rule, that is like who joined late would be going first, is they have to see it very, they must have to see the reasonability of the rule, because sometime what happen, if the employer feels that is this employee is very very important, then he can retain this employee. It is not necessary this employee who was with a special qualification, with the special skills has to go first. It is not mandatory. Then instead of it, what the employer can do, he can retrench the senior on the basis of the irregularity or inefficiency, or there should be the solid and the valid reason. So whom he thinks they are not fit, they are not doing their work properly, they can decide accordingly, they can remove, they can retrench those persons. Now the question comes in section 25H, re-employment of the retrenched workmen. So if the employer wants to re-employ any person, again he is planning to re-employ someone. This is the obligation of this person is, of the employer is, he must have to give the chance to the person who had been retrenched. So he must have to give the preference to the retrenched person. But now earlier the terms and the condition of the service would be changed. So it is not necessary, like the person would be has been engaged on a similar kind of the terms and the conditions which were applicable earlier. So now there can be the different wages if they want to re-employ this workman again. Section 25FF, it talks about compensation to the workmen in case of the transfer of the industry. And because sometime if the one of the industry they are transferring, they are giving it to, say for example, if A transfer the industry to B, then in that case this is a duty of the employer is, they must have to give the notice to the workmen. So at least they will come to know that now the owner would be different, and for this the compensation has to be given as per section 25F, because the conditions precedent to the retrenchment of the workmen so would be applicable here in case of the transfer of the undertaking. and to get the compensation, the workman has to satisfy the three conditions, the three policies. Number one is the transfer. Transfer takes place either by the agreement or by the operation of the law. So through the court order, this kind of the order has been given, or undertaking should be the industry within the meaning of section 2J of the Industrial Dispute Act. So the workman can get the compensation for the transfer of the industry is either there should be the there must be the agreement has been made between the parties. If the industry would be transferred, then the compensation would be given, or there is any kind of the court order, then they can go for this. Or undertaking should be the industry, because if someone wants to take the compensation, so it is very necessary that this undertaking or they must have to come under the definition of the industry in section 2J. And workmen should have been into the continuous service of the 1 year if they want to get the benefit or want to get the compensation. So and he must have to complete this 1 year before this industry transfers. So no compensation would be given to the workmen if no interruption of the service by such transfer. Sometime say for example, if we are talking about the migrant workers or otherwise, if they feel happy, if that industry has been transferred to such a place, they feel at ease and they feel no disturbance, there is no interruption of the service, then they won't be allowed to get any kind of the compensation. Terms and the condition under the new management, they are very much favorable, as we compare with the old one. So if they are okay with the terms and the condition of the new management, they won't be getting any compensation. New employer should be under a legal liability. So this is not the duty of the new employer would be, he will not be having any legal liability to give any kind of the retrenched compensation. So only the compensation can be paid by the old one, the earlier employer, not by this new one. In section 25 FFA, 60 days notice to be given of the intention to close down the industry. So 2 months notice has to be given, and so this is the duty of the employer is, if they want to close down the industry, they have to inform the appropriate government, and of course in a prescribed manner, and clearly they must have to state the reason why they want to transfer it, and they would be informing the government 2 months in advance. And this section does not apply to the establishment which is of a small size. So where the number of the workmen, they are less than 50 workmen has been engaged. So small size industries will not be coming under this condition. No notice is required in that case. And so this is the duty of the employer is, they would be and this provision will not be applicable on a small size industries. And second is undertaking is set up for the construction of the building, bridges, roads, canals, or other kind of the projects, so dams. So in that case the notice is not required. And this is the appropriate government is with the absolute power, they can give the exemption so to the any of the establishment. Now the next is important definition is strike. When we talk about the strike in section 2Q, strike means cessation of work by a body of persons employed in any industry acting in combination, or a concerted refusal, or a refusal under a common understanding of any number of the persons who are or have been so employed to continue to work or to accept employment. Strike means this is when these workers or body of the persons, because when they stop to do the work, when they are not doing the work into the industry and they are acting in combination, so they unite together and it is a concerted refusal, and they refuse and they understand it, they are refusing it, and so they are the number of the persons who have been employed to continue the work and they accept the employment. So this is a common understanding of everyone. They don't want to do the work and they want to cease the work now, because when we talk about the two things of the collective bargaining is, so when we talk about for the collective bargaining, we are having the two things, that is strike and the lockout. When we talk about the strike, this is the weapon has been normally, this is a kind of the coercion has been exercised by the workmen upon the employer if it is a case of the strike. And when we talk about the lockout, is the coercion has been exercised by the employer upon the workmen. So these are the two important tools for the collective bargaining. So when we talk about the strike is, or or the, now I am taking the definition of the lockout, which has been defined in section 2L. It means temporary closing of a place of the employment or of the suspension of the work or the refusal by an employer to continue to employ any number of the persons employed by him. So now what the employer don't want to employ these number of the persons, because if they are these workers, they are exercising the or coercing through their strike. So employer is also having the weapon. So sometime employer, what they do, they temporarily closes the place of the employment. So it means lock, and after that they have made everyone out. So when we talk about it, so this is a temporary closing of a place of the employment or the suspension of the work or the refusal by the employer to continue to employ any number of the persons which has been employed by him. So now this employer is not having an interest, he don't want to continue this employment, and so he don't want to engage these persons which has been employed by this employer earlier. So when we are talking about the strike and the lockout, this is very, very important, and normally when we are using these concepts, strike is a tool with the labor and the lockout is with the employer. So both has been recognized by this act, because when we are talking about strike and the lockouts, they are the statutory rights, they have been given it to employer as well as to the workmen. So this act has forbidden because in certain circumstances, and especially into the public utility services, the strike has been that is not allowed. Either it is a case of the strike or the lockout, the prohibition has been made. So when we talk about section 22, the prohibition of the strike and the lockout, as here it deals with the public utility services, because otherwise what will happen, because when we talk about the public utility services, for this we are having the one schedule has been given, and into which either we are talking about the banking facilities or the hospitals and many more services has been given. Because of this, if they would be going on a strike, the general public would be affected. So it is very, very necessary that if someone wants to go on a strike or on a lockout into the public utility services, they must have to give the notice. So for this they must have to satisfy the condition, otherwise it would be considered to be the illegal strike and the illegal lockout. So this is the duty of the employer as well as the employee. They must have to give the notice in advance, that is, and 6 months notice in advance has to be given for the strike or the lockout. But they are not allowed to move on a strike or on a lockout before the expiry of the 14 days. So it is their duty, 3 weeks notice has to be served, but they can proceed for the strike or the lockout after the expiry of the 14 days. So, and otherwise this kind of the strike or the lockout would be considered to be the illegal. So, and in section 22 clause 3, if say sometime if the already strike or the lockout is going on, then in that case this is a duty of the employer, is they would be informing the authority, but it is then in that case there is no obligation on the workmen, and employer they can report to the authority within 5 days. Already the lockout is going on, but if the already strike is going on into the industry, there is no obligation of the workmen to inform the government about it. Look, this strike is going on into this industry, so they are not boundable. And in section 23, it talks about general prohibition of the strike and the lockout. So it includes both public utility services and the non-public utility services. So they cannot go on a strike and the lockout. Into this section, a few conditions has to be satisfied. Say if the proceedings are pending before the board of conciliation, they cannot go for the strike. Or if the conclusion has come, then before the expiry of the 7 days they cannot proceed. If the proceedings are pending before the labor court, then they cannot go for the strike. But if the decision, the conclusion the decision has been given by the court, then after the expiry of the 2 months, they can go for the strike and the lockout. In case of the breach of the contract, no strike. And they have to because if they have entered into they have created a contract, and sometime if they are agree that okay, this is the settlement period, we can say that. But if someone is say for example, if they feel so there is no output would be coming, there will be no result, so of course they have entered into this kind of the contract, and they feel so there won't be outcome. So if they are making the breach of the contract, then that is not the valid one. And during the period of the operation of a settlement, or then in that case, if the settlement has been given, any kind of the award has been given by the tribunal, or any kind of the decision has been given by the court, so that is they cannot go for the strike before the expiry of the 2 months. So otherwise the strike would be the illegal strike. And in section 24, whom we would be saying the illegal strike and the lockout is, that is if the commencement in contravention of the breach of section 22, 23 and section 10 clause 3. So that is section 10 clause 3 where the appropriate government gives the order that is for prohibiting the strike and the lockout. And section 10A clause 4A, it talks about where the appropriate government that is the matter is pending for the arbitrator, or that has been referred it to the government. So then in that case they cannot go for the strike or the lockout, otherwise that would be considered to be the illegal. So the strike will not be considered to be the illegal if it is the that is initially when they started with the strike, it was not the violation of the provision of this act, and if the continuation has been not been prohibited by the appropriate government under section 10 clause 3 and section 10 clause 4E, that is will not be considered to be the illegal strike and illegal lockout. So chapter 2 deals with the authority which has been given under this act is section 3 is talking about the work committee, 4 is conciliation officer, 5 is board of conciliation, 6 is court of inquiry, and these are the non-adjudicating authorities. And when we talk about section 7 labor court, section 7A labor tribunal, section 7B is a national tribunal. So these authorities has been given under this act. So when we talk about these authorities through this section 3, 4, 5, 6, these authorities has been given to decide the matter. See, when we are talking about the work committee, so the purpose of this work committee is to promote the measures, so so they can maintain the good relations between the employer and the workmen into the industry, and they can comment upon the matter where the welfare measures are involved, or the training issue, or the wages, number of hours, bonus, or the holiday. So into this when we are talking about it, so there would be the into this appropriate government can constitute a work committee, and they can appoint the work committee by general and the special orders. So but this work committee can be established into any of the industrial establishment where the number of the workmen are 100 or more than the 100. So and there would be into the work committee there would be the representations of the employees and the workmen. So there should be the equal representation from the both the sides. When we are talking about the conciliation officer, so the appropriate government can appoint the conciliation officer, and this conciliation officer can be appointed for a specified area, and this conciliation officer can be appointed permanently or for a limited period. And this conciliation, because this conciliation would be compulsory into the disputes if it is a case of the public utility services. So the conciliation, role of the conciliation officer is very, very important when we are talking about the public utilities services. And when we talk about the duty of this conciliation officer is, he would be dealing with the conciliation officer. This conciliation officer would be without making any delay, he would be informing the so this conciliation officer will investigate the disputes without making any delay, and he would be trying to give the fair and the amicable solutions. So, and he has to give the full statement of the facts and the circumstances if the dispute has been resolved, not to resolve, and he had to inform the authority within a 14 days. So, he would be giving the report within a 14 days of their conciliation proceedings. After that, we are having the board of conciliation, into which the number has been increased, and so because the board of conciliation, they would be looking into the matter, and if they feel so, the suggestions can be given by the board of the conciliations. So this the board of conciliation, if the board of conciliation they want to give the recommendation, they can give the recommendations, but it is the duty of the this board is they must have to submit the report within a 2 months from the date on which the dispute has been referred to. And we are having the board of inquiry, because they would be making the inquiry, and they have to inform the government after making the investigation, and we can say that this is a board of inquiry is a fact finding machinery. So in section we are having the matters. The labor court would be taking up the matter. The authority is the labor court. So labor court is having the jurisdiction to take up the matter which has been given in scheduled 2nd, and the matter within the jurisdiction of the labor court would be the propriety or the legality of the order which has been passed by the employer under this standing order, the application and the interpretation of this standing order, discharge or dismissal of the workmen, including the reinstatement of or grant of relief or the workmen wrongfully dismissed, withdrawal of any of the customary concession or the privilege, illegality or otherwise the strike and the lockout. All matters other than those which are specified into the 3rd schedule can be taken up by the labor court. So, and the industrial tribunal is having the jurisdiction. He can take up the matter which has been given into the 3rd schedule. He can take up the matter which are relating with the wages, including the period and the mode of payment, compensatory and the other allowances, hour of work and the rest intervals, leave with wages and the holidays, bonus, profit sharing, provident fund, gratuity, shift working, otherwise than in accordance with the standing orders, classification by grades, rules of discipline, rationalization, retrenchment of workmen and closure of the establishments, and any other which has been prescribed. When we are talking about the 4th schedule, so that is the National Tribunal would be taking up, that is dealing with the condition of the service for change of the notice to be given. Already I have discussed this point earlier, that is, and when we are talking about that is a unfair labor practice has been given. Already we have taken up this point into the previous lecture. We have discussed which kind of the practices would be unfair on the part of the employer and which would be unfair on the part of the on the worker side. So now the penalties, they are very, very important, because if someone is committing the unfair labor practice, so imprisonment has been given for the 6 months or with a fine up to the 3,000. If someone is is going for the illegal strike and the lockout, imprisonment is there for the 1 month or with the fine, or up to the rupees 50 or 1000 for lockout, or with both. In section 27, penalty for the instigation incite others to take part into the illegal strike or the lockout, imprisonment can be given for the 6 months or if they fine up to the 1000. If the someone is in section 28 giving financial aid to the illegal strike and the lockout, so imprisonment for the 6 months or fine up to the 1000 can be given. In section 29, breach of settlement or the award, imprisonment if the someone is not making going with the compliance of the award, then in that case imprisonment can be given 6 months or if they fine, or on a continuity of the offence up to the daily per day rupees fine can be imposed. In section 30, disclosing confidential informations, then imprisonment up to the 6 months or with a fine up to the 1000. In section 31A, closure without the notice, so imprisonment can be given up to the 6 months or with a fine up to 5000. Section 31 is talking about the penalty for the offences. If the someone is making the contravention of section 33, so imprisonment can be given in up to 6 months or fine up to the 1000 rupees. So all the important things we have covered here under this lecture, and all the schedules has been mentioned here under this lecture, and it will help. I think it would be very helpful, and this is from my side. Thank you.
Hi, my name is Gillette Sam and I teach sociology at IIT Kanpur. Today I am going to tell you about an important debate that is occurring around the concept of globalization. Now, uh, within the study of globalization, there are two sets of people. The first set of people argue that globalization is very real. It's something that is happening around us all the time, and in fact, it's something that is gaining strength over time. The second set of people, and the first set of people are called the globalists. The second set of people are not so convinced that globalization is something real, and they are referred to as skeptics. Now, the skeptics argue that unlike what the globalists would have us believe, that there are things and ideas and people that are traveling across the world, across multiple borders, and that we live in an interconnected world, actually, there are many parts of the world and many types of people who are completely left out of these kind of global flows. So they would give you the example of typically indigenous communities who live across the world. And they would argue that if you look at the lives of indigenous communities, particularly tribes that are quite isolated in terms of their physical location, their lives continue without their participating in any kind of global flows. To this, the globalists would respond that even though people may live in isolated and remote locations, and they may not be directly involved in global flows, their lives today are still being influenced by events that are happening at a global scale. You can take the example of climate change. So, for instance, if there is an indigenous community that has no contact with anyone else in the world apart from themselves, but they live in an area which is experiencing an increase in sea levels and increase in the temperature. All of this may be attributed to people in neighboring countries, or actually rather events that are happening across the globe. So in that sense, even though you may not be directly participating in global flows, your everyday life is affected by what is happening around the world. Another argument that the skeptics make is in regard to what happens with the nation states. Now, initially, when discussions about globalization started, and we are talking about the 1990s, the expectation was that the nation state as an entity is going to wither away. It's going to cease to be important. Now, skeptics could point out to the world today and say, well, nation states are still important. We still live our lives based on which nation we were born in or which nation we have citizenship in. Their rules and regulations are still important for us. To which globalists would argue that this expectation that the nation state will cease to be important, that itself is a fallacy. Rather than facing a situation that the nation state becomes less important over time, we actually may be headed towards a situation where, in addition to the nation state, there are other laws which become important to our lives, and they shape our lives on an everyday basis.